Hi guys, Team CLJ has started a new judgment series dedicated solely to understanding various important judgments in different areas. To kickstart this series for the next 1.5 months, we will be focusing on important judgments in the area of competition law. The first judgment that will be discussed is that of Samir Agarwal versus Competition Commission of India and others. This case pertains to the possible existence of hub-and-spoke cartels between the cab aggregators Ola and Uber and their respective drivers. The matter was first placed before the Competition Commission of India, whose order was subsequently appealed against before the National Company Law Appellate Tribunal. In order to have a better understanding, let me briefly explain the facts leading up to this appeal. Mr. Samir Agarwal, who claims to be aggrieved by the pricing mechanisms adopted by Ola and Uber, filed information with the Competition Commission of India alleging contravention of Section 3 of the Competition Act 2002. Section 3 talks about anti-competitive agreements. It was alleged that these taxi services have used their respective algorithms to facilitate price fixing between drivers. This, according to him, takes away the liberty of the individual drivers to compete with each other and is in thereby violation of the law. The Commission, upon hearing the informant, observed that there was no such agreement, understanding, or arrangement neither between the cab aggregators and their respective drivers nor amongst the drivers themselves, and were thereby of the view that there exists no prima facie case and closed the matter. The Commission then went on to explain in detail why the allegation of the existence of a hub-and-spoke cartel in the business model of Ola and Uber would not hold good. In the conventional sense, a hub-and-spoke arrangement refers to the exchange of sensitive information between competitors through a third party that facilitates this cartelistic behavior of the competitors. According to the Commission, the same does not seem to apply to the facts of the present case. With respect to Ola and Uber, the price is estimated through the app by the algorithm on the basis of large data sets known as big data. The said algorithm takes into account personalized information such as the time of the day, traffic situation, events, and so on to determine the demand and supply situation. Consequently, the price for each rider tends to be different owing to the interplay of large data sets. For a cartel to operate as a hub and spoke, there needs to be a conspiracy to fix prices, which requires the existence of collusion in the first place. In the present case, while the drivers may have acceded to the algorithmically determined prices by the platform, this does not imply collusion between the drivers. Thus, the Commission dismissed this allegation. The Commission, while dealing with the allegation of price discrimination, observed that the price discrimination falls within the prohibition under Section 4, Subsection 2, Clause A, Subclause 2 of the Act, only when its imposition is indulged by a dominant enterprise. Section 4 as a whole talks about the abuse of dominant power. The Commission pointed out that Ola and Uber, being two independent enterprises, could not be said to be holding a dominant position collectively, since the Act does not recognize collective dominance. Therefore, this allegation regarding price discrimination was also rejected. Finally, the Commission pointed out that Ola and Uber, being cab aggregators operating through their respective apps, were not an association of drivers and that they acted as separate entities from their respective drivers. Once a rider books his ride, it may be accepted by an anonymous driver available in that area and so has no opportunity to coordinate his action with other drivers, thereby ruling out such activity being termed as cartel activity. Having regard to all these relevant considerations, the Commission declined to order an investigation by the Director General. Aggrieved by this order, the informant filed an appeal before the National Company Law Appellate Tribunal. Before moving forward with the arguments advanced by the parties and the verdict of the Appellate Tribunal, I will be elucidating the issues raised by the informant. First, CCI had erroneously concluded on the genuineness and legality of the pricing model of Ola and Uber in the absence of their defense. Second, the Commission had not refuted the allegation that the cab aggregators fix prices which the drivers are bound to follow and has therefore acquiesced the fact of price fixing. Third, the Commission has erroneously implied that price fixing done by way of an app is immune from scrutiny. Fourth, the Commission has erred in treating drivers and the app providers as a single economic enterprise. Fifth, the Commission has erred in holding that there is no agreement amongst the drivers to fix prices where the app provider is acting as a hub. And finally, the Commission was not justified in ignoring the fact that Uber's business model was challenged in USA with identical allegations and which was considered fit for investigation. Moving forward, let's discuss the arguments advanced by the parties. First, the arguments of Ola. According to Ola, they are merely an intermediary that connects two ends of the supply chain, that is, the taxi driver and the commuter. In order to constitute an offence under Section 3, subsection 3 of the Act, it is imperative that there exists an agreement between enterprises at the same stage of the service chain engaged in identical or similar trade of goods or provision of services. Since Ola and its taxi drivers are not at the same level of supply chain, there is no violation. Second, there are a number of variables that play a role in determining the price by the app, thereby making it impossible for anyone to fix prices. Further, the drivers can switch between different radio taxi apps without incurring any significant costs, which eliminates the existence of a horizontal agreement between drivers. Third, the informant is not an aggrieved person and no prejudice has been caused to him, and therefore has no locus standi. Fourth, an inquiry initiated in a foreign jurisdiction cannot be the basis for interfering with the impugned order. Moving forward with the arguments of Uber. According to Uber, the price structure offered is similar to that of meter taxis and auto rickshaws, which follow standard price mechanism at different points of the day. Moreover, the driver partners are free to charge any amount which is lower than the one recommended by the app. Second, drivers are allowed to undertake offline private or corporate duties. Third, the price recommended by Uber complies with the rules framed by the government and have been put in place to ensure that riders are protected from transportation providers arbitrarily charging high prices. Fourth, the informant has failed to make out a prima facie case. As per the Supreme Court verdict in CCI versus Sale, there is no right of hearing and notice at the threshold stage, and therefore the Commission was not required to call the cab aggregators for hearing before recording its satisfaction in regard to the existence of prima facie case. Fifth, the initiation of proceedings in a foreign jurisdiction in a similar case pertains to arbitral proceedings between two parties and is not an investigation initiated by an antitrust authority. And finally, Uber does not hold any dominant position in the relevant market where it competes not only with Ola but also several other alternative modes of transport. Now that we've discussed the arguments of Ola and Uber, let's discuss the arguments of the appellant. According to the appellant, Uber unilaterally fixes or restricts the price, leaving transportation service providers and the ultimate riders with no choice but to accept the price of Uber, thereby implying that Uber has total control on the pricing. Second, every transportation service provider is aware that it is signing identical terms on pricing, which implies that there is a meeting of minds between these transportation service providers. Thus, the offence under Section 3, subsection 3, Clause A of the Act is committed at the time of signing the Uber service agreement, alleging that there is a hub and spoke cartel, as the hub, which is Uber, fixes or restricts the prices and the spokes, which are the transportation service providers, merely accede to that fixed and restricted pricing. Third, with regard to the issue of locus standi, it is submitted that the informant falls within the definition of any person under Section 19, subsection 1, Clause A of the Act, which includes any individual who can file an information. Finally, with regards to the existence of prima facie case, it was submitted that as per the judgment of the Supreme Court in CCI versus Sale, the Commission is supposed to record minimum reasons without entering into any adjudicatory or determinative process. The National Company Law Appellate Tribunal, after hearing the arguments of all the parties, came to the following conclusions. With respect to locus standi, the question that arises for consideration is whether the term any person under Section 19 of the Act would include both a consumer who has suffered invasion of his legal rights as well as a person whose legal rights have been or likely to be jeopardized by the alleged anti-competitive agreement or abuse of dominant position. The Appellate Tribunal was of the view that when a statute like the Competition Act specifically provides for a mode of taking cognizance of allegations at the instance of a person, it has to be necessarily construed as reference to a person who has suffered an invasion of his legal rights. Any other interpretation would make room for unscrupulous people to rake issues of anti-competitive agreements or abuse of dominant position, targeting some enterprises with oblique motives. In the present case, there is nothing on record that shows that the informant has suffered injury at the hands of Ola and Uber and therefore has no locus standi. However, the tribunal, for the sake of argument, went into the merits of the case and found that the business model of Ola and Uber does not support the allegations of the informant with regards to price discrimination. It was then pointed out that since the informant only alleged that the cab aggregators used their respective algorithms to facilitate price fixing between the drivers, and no allegation of collusion between the cab aggregators through their algorithms was made. This amounted to an admission on the part of the informant that the two taxi service providers are operating independent of each other. The tribunal then addressed the issue of the hub and spoke cartel. According to the tribunal, the concept of hub and spoke cartel, based on the US class action suit of Spencer Mayer versus Travis Kalanick, has no application in India. Since the matter relates to foreign antitrust jurisdiction with different connotation, it cannot be imported to operate within the ambit and scope of the mechanism dealing with redressal of competition concerns under the Indian statute. Next, the tribunal observed that the driver partners, as also the riders associated with both Uber and Ola, have the freedom to choose the app of the competing service, including choosing alternative modes of transport. Even with regard to fare, though the Uber app recommends a fare, the driver partners have the liberty to negotiate a lower fare. It is therefore evident that the cab aggregators do not function as an association of its driver partners. Thus, the allegation of their facilitating a cartel was also rejected. Moving on, the tribunal noted that Uber and Ola are not a joint venture or a group, and thus, taken together, they cannot be deemed to be holding a dominant position within the ambit of Section 4 of the Act. Even independently, the two don't hold a dominant position. Hence, this proposition regarding abuse of dominant position was also rejected. Finally, the tribunal held that under Section 26, subsection 2, where the Commission is of the opinion that there exists no prima facie case, it shall close the matter. Whereas, as per Section 26, Clause 1, if the Commission is of the opinion that prima facie case exists, then it is to direct the Director General to cause an investigation. The Supreme Court in CCI versus Sale emphasized on the necessity of recording reasons while passing an order under Section 26. Any view without the same would demonstrate lack of application of mind and an exercise of arbitrary power. Based on this, the Appellate Tribunal found that in the instant case, the Commission has dealt with the allegations clearly, identifying the issues and recording its opinion thereon in light of the law, and thereby dismissed this appeal.